I understand I have the difficult task to present in exactly 5 minutes, not more, what we are going to do in Work Package 2. The Work Package 2 concerns the rights dimension. You remember the 3 dimensions: rights, governance, and recognition. So Work Package 2 is about rights, and therefore it seems to be appropriate that the concentration of lawyers in that particular work package is fairly high. So it's the legal rights dimension on it. So in particular, we will focus on the interactions between the pre-existing legal frames of protection and on the one hand, and the 2 compacts on the other hand. As has been already presented, there's 4 participant institutions: the Queen Mary University, the Justus Liebig University in Gießen, where I'm from, Ryerson University in Canada, and the University of Witwatersrand in Johannesburg. What is the aim of Work Package 2? The aim is basically to conduct 3 individual case studies on these interactions, the impact on the rights dimension on the European Union, Canada, and South Africa. Well, that seems fairly easy, but the difficult task, both in terms of substance and methodologically, where it's not already, everything is not yet solved at that point in time. How we are exactly going to do that is to compare the findings on these 3 regional and or national jurisdictions, how the impact of the Global Compact on migration and the Global Compact for refugees on that particular jurisdictions plays out. What we're basically going to do in terms of method is what lawyers are doing. So we're conducting desktop research. Our data is available in official data basis, so therefore we don't have to go in the field particularly, but we have to do the difficult task of doing what we are calling doctrinal construction. That is what lawyers are doing. So they try to put meaning to authentic texts. So we try to understand what the legal meaning of these soft law documents, these global compacts are, and how they relate to a variety of other texts which contain binding legal commitments of state under public international law, most importantly human rights law and the Geneva Refugee Convention is. So we have to try to understand the legal meanings, and as you may immediately accept, law is not an exact science, but rather something, a way of arguing, a way of trying to struggle over the meaning of text. So we try to understand how the meaning of text actually changes, what the changes of the meaning of the binding commitments under public international law, the human rights framework is, by way of seeing these commitments in light of what is written down in the Global Compact, and vice versa. So what is the meaning added to the compacts in light of the binding international commitments under these pre-existing legal frames of protection? So we have 2 variables. Let's say we have this international dimension, or you might even say the horizontal dimension. The question here is, how's the interplay, the intersection as we call it, between hard law and soft law, the soft law documents, these compacts, and the hard law documents, human rights treaties, the Geneva Refugee Convention? How do this human rights treaty and the Global Compact for Migration intersect, and how do the Geneva Refugee Convention and the Global Compact for Refugees, how do they intersect at the level of international law, hard law, soft law interaction? But of course we are also interested in the vertical dimension. How do this new development at the international level, the emergence of these 2 non-binding documents, the Global Compacts, how do they influence, how do they impact on domestic jurisdictions? And the term domestic here applies equally to Canada, South Africa, and the European Union as a regional domestic jurisdiction, and in the context of the European Union in particular, we are quite interested in how the emergence of these compacts has an impact upon the distribution of responsibilities between the EU and its members on the one hand, and among various EU member states in particular. And as you might remember, there was quite some political conflict. Some EU member states has refused to politically support these non-binding documents, at least as far as the Global Compact for Migration is concerned. How does that impact the implementation of these compacts at the level of the European Union? So generally speaking, we are very interested in the implementation and review processes. So the reality of soft law, this is a general finding from public international law research, the reality of soft law is in its implementation. It may not have any meaning at all if it is ignored once it is adopted, but it may have a deep impact on the practice of law when there is an effective mechanism of reviewing and checking compliance, how these documents are being implemented. And therefore we do not only look at the substance of the compacts, but also how these implementation and review processes are being conducted, and in order to understand what the potential impact of these compacts on EU asylum and migration policies are. This is our plan.